Okay, great. Thank you very much for having me. My name is Nadia Brannon. I'm an examiner with the Office of Compliance, Inspections, and Examinations. So actually, I have nothing to do with enforcement. I have to start with the standard disclosure, that the thoughts that I'm bringing to you today are those of my own and not necessarily of the Commission, the commissioners, or my colleagues on the staff of the Commission. My office, the Office of Compliance, runs SEC's examination program. And basically what we do, we examine people that are registered with the SEC and that are regulated with us to make sure that we improve compliance, prevent fraud, monitor risk, and inform policy. The results of the NEP examinations are used by SEC to inform rulemaking, identify and monitor risks, improve industry practices, and pursue misconduct. So what I'm going to do today is I'll talk a little bit about the promise of blockchain, then I'll explain the role of SEC in this space. I'll talk about recent public statements by SEC, and also recent ICO-related enforcement matters. And finally, I'll talk about our examination process. It is absolutely impossible to disagree with my predecessor speakers about the potential, the transformative potential of the blockchain technology and the distributed ledger technology. It has a broad range of applications in a variety of industries, including digital identity, distributed computing and file storage, digital media rights, healthcare records management, supply chain management. There have been implementations in pharmaceuticals, food, components, just to make a few. And certainly these technologies can transform capital markets and securities industries in a way that we can't today imagine. From equity issuance and trading to loan syndication and repo transaction facilitation, from smart agreement implementation for credit default swaps to creation of central repository of standard reference data for all products. And it can bring the unprecedented transparency to the market and to the regulators. Many large financial institutions are actively working on blockchain technologies. Hyperledger announced their release pretty recently. Yesterday, I think news were around what Google is doing in the blockchain space. In December of 2015, the first security was issued using blockchain technology, chain.com on NASDAQ link. A year later, overstock.com was the first company to issue their stock in blockchain format only. Now I'll talk a little bit about SEC mission. When the stock market crashed in 1929, so did the public confidence in US markets. Congress held hearing to identify the problems and search for solutions. Based on its findings, Congress, in the peak of the Great Depression, passed the Securities Act of 1933. The following year, it passed the Securities Exchange Act of 1934, which created Securities and Exchange Commission. The main purpose of these laws can be reduced to two common sense notions. Number one, companies offering securities for sale to the public must tell the truth about their business, the securities that they are selling, and the risks involved in investing in those securities. And number two, those who sell and trade securities, brokers, dealers, and exchanges, must treat investors fairly and honestly. The SEC has a three-part mission. Number one, to facilitate capital formation. Number two, to maintain fair, orderly, and efficient markets. And number three, to protect investors. And we work really hard to balance all three of these goals. A fundamental tenet of our regulatory framework is that an offer or sale of securities in the United States must comply with United States securities laws. This approach has been critical to maintaining market integrity and fostering investor protection for over 80 years, including through various technological changes. This issue of whether a particular investment opportunity involves offer or sale of security, regardless of terminology or technology used in the transaction, depends on the facts and circumstances, including economic realities of the business. And if an offer is a security, it has to be registered with SEC and comply with periodic disclosure obligations, or qualify for an exemption from registration, such as Section 4A2, Regulation D, Rule 504, 506B, 506C, Regulation C, Regulation Crowdfunding, or Regulation A. We at SEC have been closely following the evolution of the blockchain ecosystem, as well as the developments in ICO space, token issuances, and offerings of cryptocurrency-related products. Some time ago, we created an intra-agency distributed ledger technology working group to specifically focus on the development in this arena, and I belong to that group. The group also assists in coordination with our federal, state, and local regulatory and law enforcement partners and liaising with the industry. Since the explosion of ICOs in 2017, the SEC has taken a series of steps to inform the public and players in the crypto market about the risks in this arena. Last summer, the SEC issued a report of investigation, or so-called 21A report, that has come to be known as DAO, or DAO report. It stated that tokens offered and sold by a virtual organization known as the DAO were securities under the Howey test, and therefore subject to federal securities laws. The report confirmed that issuers of distributed ledger or blockchain technology-based securities must register offers and sales of such securities unless a valid exemptive relief is available. Those participating in unregistered offerings also may be liable of violations of the securities laws. Additionally, DAO said that securities exchanges providing for trading of these securities must register unless they're exempt. So just so you know, Howey test is a 1946 case that defined that investment contract and thus the security is an investment of money in common enterprise with reasonable expectation of profit and to be derived from entrepreneurial or managerial efforts of others. Shortly after DAO report, Commission issued an investor alert regarding public companies making ICO-related claims. Alert highlighted several trading suspensions on the common stock of certain issuers who made claims regarding their investment in ICOs or touted coin or token-related news. The companies affected by trading suspensions include First Bitcoin Capital Corp., CIAO Group, Strategic Global, and Sunshine Capital. Alert further warned consumers about various forms of microcap fraud, including pump and dump schemes. In November, SEC issued a statement urging caution around celebrity-backed ICOs. It specifically warned celebrity endorsements, that celebrity endorsements may be unlawful if they do not disclose the nature, source, and amount of any compensation paid, directly or indirectly, by the company in exchange for the endorsement. A failure to disclose this information is a violation of anti-touting provisions of United States securities laws. Persons making these endorsements may also be liable for potential violations of anti-fraud provisions of the federal securities laws for participating in the unregistered offer and sale of securities and for acting as unregistered broker. And finally, on December 11th, Chairman of SEC, Jay Clayton, issued a public statement in which he addressed to both Main Street investors as well as professionals such as broker-dealers, investment advisors, exchanges, lawyers, and accountants. He warned investors about lack of protection in cryptocurrency markets as compared to the traditional securities markets. Chairman Clayton further noted, and I'm quoting verbatim, "Following the issuance of 21A report, certain market professionals have attempted to highlight utility characteristics of their proposed ICOs in an effort to claim that their proposed tokens or coins are not securities. Many of these assertions appear to elevate form over substance. Merely calling a token a utility token or structuring it to provide some utility doesn't prevent the token from being a security. Tokens and offerings that incorporate features and marketing efforts that emphasize the potential for profits based on entrepreneurial and/or managerial efforts of others continue to be the hallmark of United States security laws." A message to gatekeepers was equally strong. Gatekeepers and others, including the securities lawyers, accountants, and consultants, need to focus on their responsibilities. Selling securities generally requires a license, and experience shows that excessive touting in thinly traded and volatile markets can be the indication of scalping, pump and dump, and other manipulations and frauds. And most recently, on May 7th, SEC issued a statement on potentially unlawful online platforms and trading digital assets. Basically, what it said is that a platform that trades securities and operates as an exchange, as defined by the federal securities laws, must register as a national securities exchange or operate under an exemption, such as the exemption provided for ATSs, or alternative trading systems, under SEC regulation ATS. SEC-registered national security exchange might have rules to prevent fraud and manipulation. As self-regulatory organization, an SEC-registered national securities exchange must also have rules and procedures governing the discipline of its members and persons associated with its members, and enforce compliance by its members with the federal securities laws and the rules of the exchange. And finally, the National Securities Exchange must itself comply with the federal securities laws and must file its rules with SEC. On the other hand, the entity seeking to operate as an ATS must register with SEC as a broker-dealer and become a member of a self-regulatory organization, such as an exchange. Registration as a broker-dealer subjects the ATS to a host of regulatory requirements. They have to have reasonable policies and procedures to prevent the misuse of material non-public information, books and records requirement, and financial responsibility rules, including requirements concerning the safeguarding and custody of customer funds and securities. An ATS must comply with federal securities laws and the SRO rules as well, and file Form ATS with the SEC. Some online trading platforms may not meet the definition of an exchange, but directly or indirectly offer trading or other services related to digital assets that are securities, thus triggering other regulatory requirements under federal securities laws, including broker-dealer, transfer agent, or clearing agency registration, among other things. People also need to make sure that they are not participating in the unregistered offer and sale of securities. Full text of all of these public statements that I just mentioned are available on the SEC website, which has a section specifically focused on ICOs, and the address is www.sec.gov/ICOs. I encourage you to spend some time looking at the information there. It has a lot of educational materials. Take a look at this slide next to me. It basically boils down the view of SEC on ICOs to 5 simple points. Number 1, ICOs can be security offerings. They may need to be registered. Tokens sold in ICOs can be called many things, but merely calling a token a utility token or structuring it to provide some utility does not prevent a token from being a security. ICOs may pose substantial risks to investors. While some ICOs may be attempts to honest investment opportunities, many may be frauds. They may also present substantial risks for loss or manipulation, including through hacking, with little recourse for victims after the fact. And we encourage investors to ask questions before blindly investing. So now a few words about our enforcement efforts. Late last year, SEC's Division of Enforcement created a cyber unit, which is focused on enforcement of several areas, such as cyber hacking and related trading, insider trading, account intrusion and disclosures, digital currencies, and initial coin offerings. SEC has filed a handful of cases on ICOs to date, and more involving related issues like Bitcoin, Ponzi schemes, and like. So in September 29, 2017, SEC filed an emergency action in Eastern District of New York to stop an ICO involving the sale of securities in connection with the sale of RE coin and diamond tokens. Stated purpose of the token was that they would be used to purchase real estate and diamonds. Investors would participate in appreciation of the value of the token as the company's businesses grew, using the managerial efforts of experts retained by the company. Offering was promoted on the company's own website and also on Reddit. The reality, however, was that tokens, in fact, did not exist. The purported team of experts that would identify underlying real estate supporting the tokens did not exist. And defendants could not pay returns because they didn't have any real estate operations. In the case called Munchie last December, the Commission expanded on its analysis of token as security. The Munchie token was styled as a utility token because it would eventually allow users to participate in an app-based ecosystem where users could receive tokens in exchange for writing reviews and could spend them at participating restaurants. The restaurants will reward visitors with tokens or pay the tokens for advertising on the platform or something like that. Munchie's white paper invoked Howey test and claimed that tokens were not securities. But the order discussed a number of other factors that led the Commission to conclude that the token was a security. I'll run through a few of those so you'll have a flavor of what we are looking at and understand a little bit about what we consider when we assert our jurisdiction. The token was marketed as investment that would increase in value as a result of Munchie's efforts in developing the platform. Keep in mind, as I read this, that the Howey test is whether purchasers are investing money in a common enterprise with an expectation of profits to be derived from the entrepreneurial efforts of others. So this seems to qualify right there. Munchie also created a limited supply of tokens and told potential purchasers that it would periodically burn them, which would increase the value of the remaining tokens. Again, expectation of profit. The token had no functional utility at the time of the token sale because the platform has not been developed. Purchasers were effectively buying into a common enterprise to create a network or a platform, not merely getting entitlement to participate in the network or platform, the equivalent of software license or something like that. The token was marketed to the crypto community generally, or crypto-oriented websites, not to restaurants, diners, or potential users of the platform. This also makes it look more like investment than any kind of utility. And finally, Munchie represented that it would ensure that its token was available on secondary exchanges. It also said that it would buy or sell tokens to ensure liquidity in those secondary markets. Again, looks more like an investment. In late January, another emergency action was filed by SEC, this time in the Northern District of Texas. Arise Bank offered securities in the form of its own crypto token. They claimed to have raised over $600 million. Arise Bank claimed to be the world's first decentralized bank, allegedly offering a variety of consumer-facing products and services and supporting more than 700 different virtual currencies. The reality, however, was that Arise Bank falsely claimed to have purchased a 100-year-old commercial bank and that it could offer customers FDIC-issued accounts and transactions. It falsely claimed that it could offer an Arise Bank-branded Visa card. It also failed to disclose the criminal background of key executives, including the co-founder and CEO, who is currently on probation for felony theft and tampering with government records. Okay, great, thank you. In the most recent case, SEC versus John Mantrol and Bitfinder, the Commission charged a former Bitcoin-denominated platform and its operator with the operations for operating an unregistered securities exchange and defrauding its users. Just to recap, Today, I talked about the promise of the blockchain, explained the role of SEC, talked about recent public statements by the SEC, and also summarized recent ICO-related enforcement cases. I skipped the section on examinations. To sum it all up, innovation in the area of blockchain have tremendous potential. We welcome and encourage the appropriate use of technology to facilitate capital formation and provide investors with new investment opportunities. We are particularly hopeful that innovation in this area will facilitate fair and efficient capital raising for small businesses. However, it is important to make sure that the disruptive nature of the industry do not pose open opportunities for fraud and ultimately harm the investing public. Only through an open dialogue and by working together, we increase the odds of success for entrepreneurs and the strong protection of investors, which is essential to the success and future of this ecosystem. Thank you. So in the interest of time, I won't take the questions. However, I will stay.
Want to take one? Or do you have to?
Okay, so one thing I just wanted to also mention, that also, there we go, right behind me, there is an address for a dedicated email box that we created at SEC FinTech at sec.gov for public to communicate with SEC. So feel free to send your questions and requests there. And I will stay for the rest of the conference, so I will be more than happy to answer questions.
All right, let's give a round of applause. Thank Nadia Brannon.